Politicians after politicians, close ones to politicians, and all of them, almost entirely from the opposition, are being put in jail under the Prevention of Money Laundering Act (PMLA). This is the sister law of the Unlawful Activities Prevention Act (UAPA). If you want to know more about the UAPA, please watch the second episode of the Justice Brief. In this third episode though, we'll be talking about the draconian PMLA that has become a nightmare or a reason of insomnia for opposition leaders in this country. More importantly, we will see how the Supreme Court almost seems willing to fail to safeguard persons against this draconian law's misuse. Narendra Modi is back as the Prime Minister, though without winning a majority this time. That's old news now, but what is of our interest is to see what the road to Modi's victory looked like. Read this report by Deeptiman Tiwari of the Indian Express. It says that from 2014 to September 2022, 121 prominent politicians were being probed by the ED. At least 115 of them were from the opposition camp. That is 95% from the opposition, all of them either booked, raided, questioned or arrested by the ED. So of course, netas were not happy. Everybody was screaming of ED being a biased agency, a toolkit for harassment, and that the aim of Modi's government was to not fight corruption like it was being projected, but to finish off the opposition. A democracy opposition mukt? Not a good idea at all. Now read this report by the same reporter. This is a few days before the elections began this year in April. At least 23 prominent opposition politicians facing corruption charges from central agencies such as the ED have received relief after joining the BJP. Their cases have been put to cold storage, or they're given clean chit, or just stuck. The report clearly reveals that not only is there smoke, but also fire in what opposition netas were saying. By the time the elections began, the opposition started calling this the washing machine effect, the process through which politicians accused of corruption avoid legal consequences by resigning from their party and joining the BJP. This is Mamata Banerjee displaying the process.
Washing machine, 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 washing machine.
Now why is this PMLA so contentious? In episode 2, through the story of Salim Malik, I told you why the UAPA was so problematic and vulnerable to misuse by the state. Those of you who haven't watched, please do. Almost the same thing happens in the PMLA. Under this anti-money laundering law, accused individuals often remain incarcerated for a long period of time. This is because of the law's stringent bail provisions that make it impossible for courts to grant bail. To grant bail, two conditions must be fulfilled like we saw with UAPA. One, that the judge should allow the public prosecutor an opportunity to be heard while deciding the bail application, which is fine. The second condition is the draconian bit, that the judge should form an opinion that prima facie, on the basis of the material submitted by the ED, no case is made out against the accused. Now this is a humongous task for a judge to do and a very risky conclusion to make. On top of this, the ED usually submits thousands of pages of documents to oppose bail and create a narrative against the accused. Any judge, and especially a lower court judge, will not be willing to risk granting bail. In May 2024, this was on display when a lower court judge in Delhi, while hearing a PMLA case, remarked, ED matters mein kaun si bail hoti hai? Who gets bail in ED matters? So the law is actively discouraging grant of bail, and the judge too, at least at the lower court level, is perhaps not independent enough to grant bail. Naturally, opposition leaders allege that the BJP is using the ED to jail top leaders of their parties, topple opposition state governments, and if failing to topple, paralyze state administrations by intimidating the state's bureaucrats. See what is happening in Delhi. Its chief minister is in jail, deputy chief minister is in jail, top leaders like Satyendra Jain also in jail under PMLA. One of them got bail from the Supreme Court after 6 months in jail. Please also remember that it is not as if agencies have not been misused before. Back in May 2013, the Supreme Court had called the CBI a caged parrot and its master's voice. The Congress-led UPA was thrown out of power by the people in the following year by a party that called itself a party with a difference. But the misuse of agencies gained mammoth proportions by the 10th year of Modi's rule, as the Indian Express reports and multiple other reports have shown. But the funny thing is, the same Supreme Court that called the CBI a caged parrot in 2013 has not voiced the same concern as boldly and as clearly today. India's democratic backsliding may have moved away from the edge, according to experts, but it is not entirely out of danger. Recent events show that despite being in a coalition, the great expectations of change in Prime Minister Modi's style of working due to pressure by allies could be exaggerated. Many politicians expect a greater push to jail opposition leaders and topple their leadership in states under Modi 3.0. So, a great burden lies on the Supreme Court, which is supposed to serve as an anti-majoritarian institution under our constitutional framework. You would remember that in March 2023, 14 opposition parties including the Congress and AAP filed a joint petition before the Supreme Court alleging arbitrary use of the ED and CBI against its leaders. They asked the court to lay down guidelines for arrest, remand and bail. Mass arrests are a threat to democracy, they told the bench presided by Chief Justice of India D.Y. Chandrachud. It is a sign of authoritarianism. The process becomes the punishment. Skewed application of the law has a chilling effect on our democracy, they said. Such great warning bells were rung by the opposition parties. But the Supreme Court refused to entertain the petition, with Chief Justice Chandrachud stating that there could not be exclusive guidelines only for politicians. Fair enough, and there is definitely a good reason for not doing so. But what you should note is that the Chief Justice asked the political parties to approach the court in individual cases where there has been a specific instance or instances of the agencies being used to selectively target leaders. On the basis of the law that we have laid down, we can evolve general principles with respect to the facts of the individual case, the Chief Justice had promised. 15 months have passed and only 4 months remain for Chief Justice Chandrachud to complete his 24-month tenure as the country's top judge. Yet, as the master of the roster, he has failed to list 3 very important cases relating to the PMLA. Experts say they could help evolve these general principles. These 3 cases are: number 1, review petitions filed against the judgment upholding constitutionality of the PMLA, 2, the question of the money bill, and 3, the case of Ritu Chhabria. These 3 cases are very important and could seriously help curtail the misuse of ED. The cases raise questions about the constitutional validity of the PMLA and how it is applied in cases. I will tell you about these in brief, but if you are interested in knowing more, go ahead and read my report at Article 14. This long lecture by Chief Justice Chandrachud at Oxford in June this year. Listen to what he says.
The purpose-oriented approach of the state, the modern state, is predominantly reflected in provisions which deprioritize the rights of individuals to achieve a larger collective good, particularly in legislation dealing with areas such as economic development or national security. In addition, the state, which is vested with the power to protect and enforce the rights of persons, may adopt a paternalistic approach by viewing citizens as its subjects, as not as persons. The second way in which the law dehumanizes is by not granting institutional recognition or by granting partial institutional recognition to personhood.
In other words, Chief Justice Chandrachud emphasized the role of courts in balancing individual rights against purposes of the government. His tenure as the country's top judge ends after 4 months. Yet in the past 20 months, the Supreme Court under Chief Justice Chandrachud has not stepped in to decide 3 long pending crucial cases that experts said have a direct nexus with individual rights, including liberty. Let's look at the first case, review petitions against the PMLA judgment. This judgment was pronounced in July 2022. About 200 petitioners had challenged various sections of the PMLA on the grounds that it is constitutionally invalid. Some of these sections were very controversial and gave the ED the wide powers relating to arrest, attachment, search and seizure. Like the ED's power to search any property and seize any record, even if there is no FIR in the case. Although only high-ranking officers of the ED can authorize such a search and seizure, obtaining a warrant from a court is not required. A reason to believe is enough. These provisions were okayed by this Supreme Court judgment. The burden to prove that an accused is not prima facie guilty in order to successfully get bail also falls on the accused himself. This is unlike, say, any other law where the burden is on the state to prove the accused is guilty. So, this reversal of burden of proof was on the accused was also upheld by this judgment. A three-judge bench headed by Justice A.M. Khanvilkar had heard the case and passed the judgment. Khanvilkar, who retired a few days after this judgment, did not enjoy a great reputation and is currently serving as the Lokpal of India after his retirement. He is the same judge who also made the UAPA law more stringent and regressive. More on that in the previous episode. After this judgment, some petitioners like Karti Chidambaram filed a review petition challenging certain findings of his judgment. Because Justice Khanvilkar had retired, the matter went before the then Chief Justice of India, N.V. Ramana, and the two other judges who were on the same bench as Justice Khanvilkar. Chief Justice Ramana admitted the review petition and said that at least two of the issues in the judgment require reconsideration. As the master of the roster, he was to constitute a bench to hear the review petition, but since he too was retiring, the task fell on the next Chief Justice of India, U. Lalit. The case came up again few days before Lalit's retirement and he asked the matter to be placed before the next Chief Justice of India. But after the next Chief Justice of India came in, Chief Justice Chandrachud, the matter was never taken up. 20 months have passed. Who knows, perhaps he too might take it up days before his retirement and pass the baton to the next Chief Justice. But there are very important issues raised in the petition. Very problematic aspects of the judgment that the Supreme Court itself admitted needs reconsideration. Chief Justice Chandrachud continues to fail in constituting a bench to hear these review petitions. So one must ask why the Chief Justice of India continues to ignore this case, which could help people suffering the ED's unfair use of powers. The second case is the money bill question. Now there are certain conditions outlined in the Constitution of India that need to be fulfilled if a bill is to qualify as a money bill. You can't introduce a bill on road safety, for example, as a money bill. It has to be a financial matter like taxation, public expenditure and appropriation of money from the Consolidated Fund of India. The government can introduce a bill as a money bill only in the Lok Sabha and the Rajya Sabha cannot reject a money bill. So such a bill forgoes the scrutiny of the upper house of parliament. To your surprise, many of the draconian changes made to the PMLA were done through money bills. 5 money bills. The Finance Acts of 2015, 2016, 2018 and the Finance Act number 1 and the Finance Act number 2 of 2019. The 200 petitioners who had challenged the constitutional validity of the PMLA law in the case I previously detailed had also raised questions about the validity of the procedure followed to add these draconian additions to the PMLA via money bills. While Justice Khanvilkar's bench upheld the PMLA provisions, it left the question of money bill to a larger bench of 7 judges who will have to decide the question. You see, this larger question of what constitutes a money bill is already pending at the Supreme Court since November 2019. A 5-judge bench headed by the then Chief Justice of India, Ranjan Gogoi, while hearing a different and separate case, had referred this question for a larger bench. The concern was that a government that is short of a majority in the Rajya Sabha can use the money bill route to get a bill passed in Parliament without caring if it is illegal. This is perhaps what has happened in the PMLA case since Modi's government did not have enough support to pass bills like these back then. If the issue is decided against the government, all the draconian provisions of the PMLA will become invalid. Perhaps then the Parliament could force the government to bring in a better law to combat money laundering with safeguards. Yet, the Supreme Court sees no hurry in the matter. One must ask the Supreme Court whether it does not care about the wrongful use of the PMLA and ED by the present dispensation. And if it does, what is preventing them from hearing this case? What about Chief Justice Chandrachud's promise to the opposition parties last year? There was some movement in this case last year in October. When lawyers mentioned this case before Chief Justice Chandrachud's bench, he remarked, "next week." The next day, a notice was issued by the Supreme Court Registry listing 6 matters, including this money bill question, before a 7-judge bench on 12th of October. On 12th of October, petitioners urged the court to prioritize the money bill matter as it was a live issue, hinting at the arrest of political dissidents. BJP government's lawyer, Solicitor General Tushar Mehta, vehemently opposed this request, saying the court should not decide priorities based on political exigencies. 2 months later, on 22 December, a circular was issued by the Supreme Court notifying that the money bill case would be listed for hearing on 30th January this year. But it was mysteriously deleted from the list. Was there pressure? If so, who pressured the Supreme Court? Shouldn't the Supreme Court think about what message such incidents send to the public? In 2018, when the 4 senior-most judges in the historic press conference said that somebody from the outside is controlling the Chief Justice of India, were they referring to instances like this one? Maybe the Supreme Court and Chief Justice Chandrachud should introspect and come up with some answers so people don't get such an impression. The third case is the Ritu Chhabria case. You see, in April 2023, a 2-judge bench led by Justice Krishna Murari of the Supreme Court ruled that an accused person is entitled to default bail if the charge sheet filed by the state is found to be incomplete and requires further investigation. Under the Code of Criminal Procedure CRPC 1973 and now the Bharatiya Nagrik Suraksha Sanhita, the time period for an investigative agency to complete an investigation and file a charge sheet ranges from 60 to 90 days depending on the type of crime. If the agency fails, an accused is entitled to default bail or automatic bail. But in order to defeat this default bail, investigative agencies these days, they file charge sheets despite not completing the investigation, just to defeat the right to default bail. This leads to the accused remaining incarcerated for a long time. This great judgment in Ritu Chhabria noted that a charge sheet that clearly states that the investigation is pending cannot, under any circumstances, be used to defeat the right to default bail. The court also held that the right of an accused to default bail is a fundamental right. When the central government and ED realized what had happened, they went up to the Supreme Court in a separate case and brought this judgment to the notice of Chief Justice Chandrachud's bench. He was sitting on a 2-judge bench that day. Now the judgment was also passed by another 2-judge bench, that of Justice Krishna Murari. So a 2-judge bench cannot stay the judgment of the other 2-judge bench. It can disagree with it, but it cannot stay it. As per rules, the centre should have filed a review petition before the same bench of Krishna Murari if it disagreed with the judgment. Yet, on Tushar Mehta's request, Chief Justice Chandrachud, God knows under what authority, effectively stayed the judgment. This was widely criticized by experts. What should he have done? Senior advocate Devadatt Kamath told me that if the bench believes that a previous case has been wrongly decided, it is required to refer the decision to a larger bench which can then reconsider it. It is settled law. A bench of equal strength cannot simply overrule it. Yet, these settled principles of law were ignored by Chief Justice Chandrachud's bench. Did concerns of judicial propriety not bother Chief Justice Chandrachud before he rushed to effectively stay the judgment despite not having the power to? Maybe everyone needs to ponder over this. The matter was ultimately sent to a 3-judge bench headed by Chief Justice Chandrachud himself. The judgment is still stayed, and since May last year, the matter has not been listed for a hearing. The judgment was progressive because it came as a huge relief to those people who remain incarcerated due to multiple factors, including delay in investigation by the police and the clever tactics that agencies like the ED use. When the Chief Justice stayed this judgment, he should have also answered if he is willing to expedite bail petitions of roughly 2,34,000 persons at lower courts and 1,11,000 at the high courts. Is it even possible? On a parting note, let me tell you this. Sitting with Chief Justice Chandrachud in that two-judge bench that stayed this judgment was Justice J.B. Pardiwala, who also signed off on that stay order. This was in May last year. Skip to July 2024, the same Justice Pardiwala, while heading a bench, rebuked the NIA for opposing bail of a person who remained incarcerated for 4 years. So much anguish was expressed by him. Do not make a mockery of justice. The accused has the right to a speedy trial, whatever offence he has committed. Justice Pardiwala commented and released the man on bail. Great order. But this thought seemed to have gone missing when he signed off on that stay order in the Ritu Chhabria case. And this is again a display of vibe jurisprudence. Is a person not entitled to automatic bail even when the Constitution of India requires it? Does a person have to spend all their money, time, resources, mental health on folding their hands before the judges of the High Court and Supreme Court? Just so that the media can publish some great comment made by the judge, which mostly won't make it in the written judgment? Maybe the judges need to think about this, and maybe you too should ask these questions. That's it on this episode of the Justice Brief. Like the video and share it. I will see you all very soon. Until then, stay curious, stay informed, and remember, the law matters.